just false. I mean, we certainly have taken all the resources that we have that are available, and we're using them very effectively, I think. Occasionally, he just says that I'm not doing enough, and that is a more interesting question. What's enough in fighting corruption? And so my response to that has been that I have been recognized by a variety of folks, and most notably Jim Scarantino, who was never somebody who was easy to sway, but who did an analysis that said that I had done more to fight corruption than like my three predecessors combined, and I think that that's probably true. And interestingly enough, last year the Republican state party chairman actually said that I was one of the few people that was actually doing something to fight corruption in New Mexico. And now that it's political season, they seem to have forgotten. I can assure you and everybody else that what we have done for fighting corruption is what needs to be done to fight corruption in New Mexico, which is to take the cases seriously. And to persevere, to put the resources in it that are necessary to persevere. So for instance, I will say this about the Secretary of State case is that it took a couple of years to do the investigation to get the evidence that we needed to go to a grand jury. We presented sufficient information to the grand jury to get indictments on all of the defendants, including the one that's claiming that this is politically motivated. And so the grand jury obviously felt like there was sufficient information for us to move forward. We have for a year now, I suppose, been fighting defense motions that are designed to keep my office from doing the prosecution, and in the long run we will persevere in that. And once we have completed our perseverance in all of those, then we will get this case in front of a jury, and then it'll be up to a jury to decide whether there's actually corruption there or not. Take the Jerome Block case. Actually, that one is the one. It's the simplest from a factual basis. I mean, there are basically sort of 2 or 3 events that are basis for that. Whereas, say in the Region 3 Housing Authority case, I mean, there were 2 or 3 years worth of incidents that are the basis for the charges against them. Mm-hmm. Whereas in the Jerome Block case, they all occurred during one election cycle, basically. And so, but there's a case where we were prosecuting that case under what's called we are prosecuting that case under what's called the Voter Action Act. Mm-hmm. It's a new statute. It's a statute that applies to the Public Regulation Commission, and the Public Regulation Commission was created new within the last. I should be able to tell you when, because I was the chairman of the committee that did the statutory framework to create while I was in the legislature. Mm-hmm. But one of the things that we did is we created a little bit later on public financing for Public Regulation Commissioners. So the act that we're prosecuting under is the act that was created to do the public financing for the Public Regulation Commissioner. And in that case, the district court judge has ruled that that statute, which has a clause in it that says that if there's a violation, that the Secretary of State can fine the bad actor, or they can refer it to the Attorney General's office for prosecution. That's the part that we're all fighting over. And traditionally in New Mexico law, for 100 years, as far as I know, more than 100 years, the courts have construed that the word "or" means "and/or." It means one or the other of those items, or both. The judge in this case has ruled that for whatever reason, that the legislature for this particular statute meant that "or" means "or" but not "and." And so the judge ruled that since the Secretary of State has fined him already, that precludes us from prosecuting under that statute. We don't agree with that. Okay. But it's in the Court of Appeals. We've appealed it. It's in the Court of Appeals. And once again, the judge allowed an interlocutory appeal on that, I suppose. But so we have to wait to continue with the trial in the Block case until the Court of Appeals decides what "or" means in that statute. Well, once that's done, if it happens again in the future, everybody will know what "or" means, but right now it doesn't. And that's really my point, is that nobody else has ever brought these kinds of corruption cases. And so they're cases of first impression. They're in the courts, and defense lawyers are able to throw these roadblocks in the way of actually getting in front of a jury by raising these issues, and they have every right to raise them. I mean, I'm not criticizing them for doing that, but it does slow down the process. It'll probably be anywhere between 6 months and 18 months before the Court of Appeals rules on what or means. Every year we've asked the legislature for more investigators and more prosecutors, and every year they've given me a cut in my budget. I mean, although the cuts in the budget I've absorbed elsewhere, I haven't decreased the number of prosecutors or investigators that I have that are working on these kind of crimes. We every year have asked the legislature for more direct authority to prosecute state public officials when we find that there are instances of corruption, and there's a reason for that. I mean, it goes back to what you and I were talking about previously, which is if the legislature would pass a statute that made it clear that the Attorney General's office was the prosecuting agency for these, then the defense attorneys wouldn't be able to raise all of these motions claiming that I don't have the authority to prosecute. But I have said many times, and publicly said many times, that in any case that you can think of where there's been a newspaper article about allegations of wrongdoing, particularly by state elected officials, we either have or continue to investigate. I mean, that we don't take those things lightly, and so once again, I mean, if you're thinking that I'm not, it may be based on the political allegations that my opponents made, or that various of my opponents have made, not just my opponent in the race. But you know, when you prosecute somebody like the Blocks, they start a lot of rumors about bad things that you're doing because they think that that'll help. You know, I mean, I'm certainly aware of bad rumors that have been started by the Blocks. And this is why I know that maybe it frustrates you guys to have to file a formal complaint, but when a formal complaint comes in, then we actually do have a process where we send a letter to the agency within a couple of days after we get the complaint that says, hey, why aren't you guys giving up this document? And we sort of do it in that way. I mean, they can come back to us and say, this is why we're not, and that slows the process down. But we get, I don't know if I get a complaint a day, but I mean, I get on the average of like a complaint a day on IPRA and the Open Meetings Act, because they copy me on them too. I see all the complaints too, or I see that there is a complaint. There's an interesting flaw for me. They PDF the complaints and they send them to me on my BlackBerry, and I can't open the PDFs on my BlackBerry. So I don't always know exactly what the complaint is, but I get a line that says there's been a complaint raised against the Santa Fe School Board or whatever. So I know that. But to the best of, once again, to the best of my knowledge, I think that this is important to state, because I don't go down and sit with the guys every day and say, okay, did you get your letter out today? But we have a process so that when we get a complaint in, that letter's supposed to go out fairly quickly from our office that says we received a complaint that you're not complying with IPRA. Why aren't you complying with IPRA? And I would guess that in about 70 or 80% of those cases, it's just what you said, that the agency says, okay, you know, the AG's office says, why didn't we give it to them? Let's give it to them. And in about 30% of the cases, more than that, in cases where the governor gets involved. I mean, I don't criticize the governor a lot, but the governor does not believe in IPRA. I mean, you've seen that. I mean, you're right. I believe that you're correct, that the agencies as a whole do everything that they can to slowball IPRA. And we've chided them for that. I mean, we've sued them for that. We've done all that kind of stuff. But they're more afraid of the governor than they're afraid of me right now, to tell the truth. I mean, agencies that know I'm going to sue them will still drag their